Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 9 and 10 on the speed of 90 words per minute. Start. Nonetheless, as noticed above, and which is evident from the records, the Tehsildar himself processed the file and recommended that the leases were valid and did not suffer from any infirmity. In essence and in pith and substance, the Tehsildar applied his mind to the said allotments and accordingly made a recommendation that the petitioners were eligible to receive the said allotment of lease from the Gaon Sabha. In the opinion of the court, once the Tehsildar had applied his mind being the competent authority for approval, then, in that view of the matter, the Tehsildar will be presumed to have approved the said allotment in favor of the petitioners, and which has been noticed by this court while granting an interim order on 22/1/2008. This act of the Tehsildar, even though subsequent in point of time, cannot be faulted with. The factum of the report and recommendation of the Tehsildar has been noticed in the impugned orders. This fact has been stated in para 7 of the petition and has been accepted as a matter of record in para 5 of the counter affidavit of the private respondent. The same has also not been questioned or disputed in the counter affidavit. The Tehsildar, therefore, having recommended favorably, will be presumed to have applied his mind to the same. To approve means to be in favor of or to judge favorably. It is to favorably sanction and confirm an act. This expression is an act of approval, ratifying an authorized act. It is an assent which is an approbation through a formal attestation. The Tehsildar's recommendation was favorable to the petitioners and therefore it was a conduct by a competent official approving the allotment. The respondents have not been able to bring on record any material to the contrary, nor has the state filed any affidavit of the Tehsildar controverting the said fact. In these circumstances, it cannot be said that the approval was bereft of any orders of the Tehsildar, who was the authority competent to grant the approval. Putting of signatures by the subdivisional magistrate might therefore be superfluous, but the exercise of the discretion by the Tehsildar in supporting the recommendations cannot be said to be an act either without authority or without jurisdiction. In the opinion of the court, the recommendation made by the Tehsildar will amount to his approval, and in the aforesaid circumstances, the findings recorded by the authorities below on that count cannot be sustained. The impugned orders dated 29/8/2007 and 31st 12 2007 are hereby quashed for the aforesaid reasons. So far as the issue of eligibility of the petitioners and the issue of cancellation on other grounds of irregularity is concerned, it is open to the collector to take appropriate action in case he finds that the allotments were otherwise made in favor of ineligible persons, provided that the limitation as prescribed under the provisions of section 198 permit him to proceed to do so. The writ petition is allowed subject to the aforesaid observations. The finding of the prescribed authority that they did not get their names mutated independently would not be detrimental and cannot be an adverse circumstance to deny them their independent title over the land to the extent of their share. He further contends that even if subsequent settlement proceedings have been carried out under the UP Consolidation of Holdings Act 1953 and the co-tenants have failed to get their names recorded, then such an omission cannot take away their rights which they are asserting before the state. The submission, therefore, in short, is that their independent right in the holding also did exist and there was no bar operating against them as concluded by the prescribed authority in terms of Section 49 of the UP Consolidation Holdings Act 1953 in the sealing proceedings. The appellate authority, according to him, also misdirected itself by recording that the bar of Section 49 of the UP Consolidation of Holdings Act will be attracted as the sons had failed to get their names recorded for a long time. He has further invited the attention of the court to the documents, namely the statement of the beneficiary under the will and the attesting witness which was recorded before the prescribed authority in case number 208 of 1988, State versus Shiv Charan Singh under the Sealing Act. He submits that the said statement clearly proves the execution of the will and its attestation. As such, the will had been proved through cogent evidence in terms of Section 68 of the Indian Evidence Act. He submits that the fact that the said statements were recorded before the prescribed authority has not been controverted before this court, and in view of this, the findings recorded by the authorities below that there was no evidence to prove the will led by the petitioner is perverse. Accordingly, he contends that the impugned orders deserve to be quashed. The rejoinder to the counter affidavit has already been filed and is on record. Coming to the question of execution of the will by Ishwari Devi, it is undisputed that the will was unregistered. According to the provisions of Section 169 of the UPZA and LR Act 1950, No registration was required for a will bequeathing tenancy rights till the year 2004, when an amendment was brought about making such a will to be compulsorily registrable. The will is admittedly of the year 1986, and therefore merely because it was unregistered will not take away the effect of the instrument unless it is established that the same was not proved. The contention of the state, therefore, that the will was unregistered and the finding of the authority discarding it on this ground cannot be sustained. So far as proving the will is concerned, according to the records available before this court and which remains virtually uncontroverted, indicates that the beneficiary under the will, Rajendra Singh, gave his statement indicating the circumstance of the execution of the will, and one of the attesting witness, Mool Chand, had deposed before the prescribed authority that the will had been executed.